Thank you, Mr. Chairman. At the beginning, I'd like to enter into the record a statement from the senior senator from Texas, Senator Cornyn. I'd like to thank each of the members of the panel for being here, in particular Ms. Fulton and Ms. McBath. Thank you for being here. Thank you for sharing your stories. Every parent understands the mourning you are feeling. And it is always a tragedy when a child loses his life. And please know that we are all feeling your loss and express our very sincerest condolences. Much of the discussion this afternoon has concerned the tragic circumstances of the Trayvon Martin case. And none of us in this hearing room were there that night. None of us knows precisely what happened. We do know that there was a violent altercation between an Hispanic man and an African American teenager. And we know that at the end of that confrontation, the teenager was dead. What exactly occurred that night? No one in this room likely will know for sure. But we do know some things. We know that our system of justice has a process for ascertaining what happens when there is a violent confrontation, particularly one that leads to the loss of life. And that process is a jury trial. And a jury of Mr. Zimmerman's peers heard the evidence in that case. He was prosecuted in that case. And the jury rendered a conclusion. We don't know if the jury was right or wrong, but we do know that the jury system is the only system that our judicial system has for ascertaining what happened, particularly when you have a one-on-one confrontation. It can be particularly difficult to determine what the facts are. But we also know that the subject of this hearing, the stand your ground laws, was not a defense that Mr. Zimmerman raised. So this entire hearing, the topic of this hearing is not the issue on which that trial turned. And sadly, we know that some in our political process have a desire to exploit that tragic, violent incident for agendas that have nothing to do with that young man who lost his life. We have seen efforts to undermine the verdict of the jury, and more broadly to inflame racial tensions that I think are sad and irresponsible. I recognize that for the family, you're simply mourning the loss of your son, and I understand that. But there are other players who are seeking to do a great deal more based on what happened that Florida night. I would note additionally that the chairman of this committee a moment ago made I thought, remarkable statement that to the effect that no one could reasonably believe that stand your ground laws protect those in the African American communities who are victims of violent crime. I think that's a remarkable statement on many, many fronts, including the fact that a great many African Americans find themselves victims of violent crime and have asserted this defense to defend themselves, defend their families, defend their children. But I also find it remarkable because the assertion that no one reasonably could suggest this benefited the African American community is drawn into remarkable relief when one keeps in mind that in 2004, a state senator in Illinois by the name of Barack Obama co-sponsored an expansion of Illinois' law providing civil immunity for those who use justifiable force to defend themselves. So the notion that stand your ground laws or some form of veiled racism may be a convenient political attack, but it is not borne out by the facts remotely. I want to secondly note the issue of ALEC, an organization that exists to encourage common sense legislation in state legislatures. I would like to enter into the record multiple letters that have been submitted to me by organizations that are concerned about the targeting of ALEC in conjunction with this hearing. And I would note that it should always be a concern when you see the United States Senate targeting the exercise of free speech. This observation is not unique to me. Indeed, on August 8, 2013, the Chicago Tribune wrote an editorial that stated free speech isn't always free. It gets downright cumbersome when senators have you on their enemies lists. And it would be wrong for a U.S. senator to use the power of his high federal office as a cudgel against his enemies. And I certainly hope that this Senate hearing does not become an avenue to suppress free speech. A final point I'd like to make. By its definition, the Stand Your Ground law does not apply to aggressors. It explicitly excludes aggressors. I would note, Ms. McBath, on the facts as you've described, that evening your son lost his life. The defense would not apply, would not even arguably apply. It is a defense that only applies to those who are the victims or potential victims of other violent aggressors. Indeed, it is only triggered when there is, quote, an imminent attack that could cause death or serious bodily injury. So this is a doctrine that by definition does not apply to aggressors and only applies when death or serious bodily injury is at risk. And so the question that all of us have to ask is, in a confrontation between a violent aggressor and a potential innocent victim seeking to protect himself, herself, or her children, with whom do we stand? And I, for one, believe we should stand with the innocent against aggressors. That is why the right to self-defense has been so critical for time immemorial. And I hope that we will not see the constitutional rights of innocent citizens sacrificed because of political agendas of some. Thank you.